Another high-stakes Hollywood legal war has erupted. Justin Baldoni's bombastic $400 million defamation case was tossed out, and now the New York Times is suing him. What's going on? Who's really in the wrong? And what does this mean for freedom of speech in media? All right, let's get into it. We start with It Ends With Us, the 2024 film directed by and starring Justin Baldoni. Shortly after its release, Blake Lively filed a complaint with the California Civil Rights Department accusing Baldoni, his production company Wayfarer Studios, and others of sexual harassment, retaliatory behavior, and creating a hostile work environment. Lively alleged Baldoni improvised unwanted kisses, discussed his sex life on set, entered her trailer while she was undressed, and used PR strategies to undermine her. The Times then published an exposé titled, "We Can Bury Anyone Inside a Hollywood Smear Machine," detailing alleged messaging and public relations maneuvers from Baldoni's team. That article set off a chain reaction of lawsuits. On December 31, 2024, Baldoni and Wayfarer, along with other named parties, sued the New York Times for defamation, false light, promissory fraud, and breach of contract. They claimed the Times had cherry-picked communications, removed context, and published narratives that hurt Baldoni's reputation. Then, on January 16, 2025, Baldoni amended his suit to add Blake Lively, her husband Ryan Reynolds, and her publicist Leslie Sloan, alleging extortion, defamation, and conspiracy. In parallel, Lively's original suit continued, aiming to hold Baldoni accountable for her harassment claims and their fallout. On June 9, 2025, Judge Louis J. Lyman dismissed Baldoni's $400 million countersuit and the associated claims in a 132-page decision. The ruling found that Lively's allegations, made to the CRD, were legally protected and thus not actionable as defamation. Also, the Times reporting was protected under New York's fair report privilege. Coverage of official legal proceedings typically shields journalists from defamation liability. The judge allowed Baldoni to refile narrow claims, like breach of contract, but rejected the primary defamation and conspiracy arguments as lacking factual or legal basis. Let's take a little fast forward to late 2025. The Times has turned the tables and filed suit against Baldoni's Wayfarer Studios in New York Supreme Court. Their goal is to recover legal fees and costs under New York's anti-SLAPP law. They allege Baldoni's initial lawsuit was meritless and intended to suppress free speech, particularly the Times reporting. Specifically, the Times requests compensatory and punitive damages, plus attorney fees and costs. In their complaint, they contend Baldoni's suit harassed, intimidated, punished, or otherwise maliciously inhibited the Times' exercise of free speech. The Times claims it spent at least $150,000 defending the case. Baldoni's attorney, Brian Friedman, has fired back. Win, lose, or draw, we refuse to cave to power brokers. If the current laws protect legacy media in this manner, perhaps it's up to us to ignite that change. Friedman has pushed back against the anti-SLAPP defense, arguing such laws should not be a shield for major media to avoid accountability. At the same time, Baldoni's team has declined to refile the sweeping defamation case, shifting toward more limited claims, like contractual. This case sits at the intersection of celebrity, media, law, and censorship. A few key themes to watch. Free speech versus accountability. The Times asserts that journalism, especially covering legal claims, must be protected. Baldoni challenges how far those protections go when reputations are on the line. Anti-SLAPP precedent. The Times' use of anti-SLAPP provisions to recover legal costs is one of the more aggressive uses in such celebrity litigation. This could influence future defamation cases. Celebrity litigation trends. We're seeing more lawsuits by public figures against media entities, but courts are increasingly unwilling to grant sweeping defamation claims when privilege protections apply. Public perception and reputation. Regardless of legal outcomes, public perception often wins. This legal joust plays out on social media, entertainment reporting, and among fans. Lively's original sexual harassment case is slated for trial in March 2026. Meanwhile, the Times suit against Baldoni proceeds. Justin Baldoni's legal war with Blake Lively and the New York Times continues with sharp turns, lawsuits dismissed, countersuits filed, and now a new suit for legal fees. This clash isn't just personal. It raises bigger questions. Can media outlets act freely when in the crosshairs of powerful figures? How far can defamation suits stretch before they cross into suppression? Whenever this court drama ends, one thing's clear. In the battle between Hollywood reputation and press protection, every ruling sets a new line in the sand. Let me know what you think. Did Baldoni go too far, or is the Times overreaching? Drop your thoughts below. And if you like this video, hit like, share, and subscribe. See you in next video.